Mr. President, to debate the bill.
Senator Herndon, you have the floor.
Mr. President, I just wanted to talk about some of the details of the bill that I'm just a little concerned on the actual process of the bill. And I'll just detail a few of them. My timeline is I've scratched out for the bill. By January 1st, 2025, the board will appoint a review committee. They could be on that review committee, so the library or school board could be on the committee itself. The board would create a form, then a parent would file a form when challenging a book, and then there's no time limit in the legislation by which the review committee would review the form and the request to consider the material. But then once the committee decides to do that, and assume the board is going to create a policy and maybe they'll have a timeliness to that, once they do that, hopefully the board will then create in their policy that they're going to tell the parent that filed the form that they're going to tell them about the public hearing that's coming up, because the legislation doesn't require the parent who filed the form to be notified. It only requires the committee to publish in the paper of record a 7-day notice that they're going to have a hearing. And then once they have a hearing, the legislation doesn't require that the decision of the review committee be made in any particular time limit. But they could make it that night, but then there is a requirement in the legislation that the decision be notified to the parent within and that the parent could ask for reconsideration within 7 days. My concern is that what if a parent files a form and they go on vacation because they don't know when this committee is going to meet, and they're on vacation and they're not able to attend their own hearing because they don't get personally notified of their own hearing. And hopefully the boards will take care of that. My other concern is that once the parent decides, if they do happen to get the notice and respond in time, that they want to appeal to the whole board, let's pick a day of the month. Let's say it's the first Monday that they get that notice. Library boards and school boards don't meet very often. So to actually act as the appeal process to the review committee, the library and school board would have to meet, and they're only given 7 days in the legislation to review. And on a regular meeting, they need 5-day meeting notice to put this on the agenda. And if they hold a special meeting, they're going to have to get the whole library or school board together with a 24-hour notice to have this on the agenda, because the library or school board cannot act as a body and have a decision without an officially noticed meeting according to our open meeting laws. So my concern is that you get the decision of the review committee and the parent may not actually get a decision from a library board or a school board. And if they don't meet, then within the 7 days of when the parent asks for reconsideration, then it's considered that they denied the reconsideration. So the parent really didn't get that second step of review. That's a concern. It's the way the legislation's written. It's also going to be the practical reality on the ground. Maybe the school boards and library boards can come up with a way around that. I don't know. My next concern is after that denial at that reconsideration, we enter into the judiciary process, the judicial process, and we're using Chapter 52 of Title 67, which is the Administrative Procedures Act, which defines agency as state boards and state agencies and state commissions, and it doesn't define them as local political subdivisions. And I did talk to the Attorney General's office, and he said the way the legislation is written, it says on page 3 in subsection 5 that the parent may seek judicial review as provided by Chapter 52, Title 67, but Chapter 52 of Title 67 does not provide judicial review of library and school board decisions, at least on its face. So that's a concern that we're putting in Idaho Code language that is not technically there, and the Attorney General tells me, well, maybe the judge will liberally construe that we can use the judicial procedure over there. However, I'd like to point out a problem at this point. So this could be the parent's first real appeal of the review decision. This could be their first one, and it requires them within 28 days of the lack of action by the full board or an action affirming the review committee's decision, the parent only gets 28 days to file a judicial action in district court. 28 days, because that's what's in the Administrative Procedures Act. And that would be at their cost. And there's no process in the Administrative Procedures Act where they can recoup any of those costs. So this is going to essentially make the parents the police of our libraries. That's what this does, at their cost. So if a review committee doesn't agree with them and the whole board doesn't actually meet to reconsider, and so the review committee's decision is final, the parent has to go to the district court. And I thought that we were trying to avoid things going to the district court, because I thought our courts were already too full. But if we accept that the Administrative Procedures Act authorizes judges to, at the district court, to act on these appeals, they're all at our district courts. So every single challenge to every single book that a parent didn't like the review committee's decision is now sitting at a judge. And now, according to that act, the board, the library, or the school has 42 days to provide the record to the court. And then the judge is going to have to render a decision. So we've got a whole lot of judicial activity here. And I thought that's what we were trying to avoid. And it's at the cost of Idaho parents. And now I just think we're really in a position where the parents are going to be the police of their local libraries and schools. And the burden's entirely on them. And I wish we could do that differently. And then I'll just note that whatever the ultimate decision is at that point, and that's a may option for the parent. He doesn't have to keep going. He could have stopped before going to court. But whatever that decision is, at that point, that is the decision. The parent never gets to get this in front of a jury. So even in the court process, it's only confined to the judge. And if ultimately the decision is that it's not harmful to minors, which would be great, if the parent still disagrees, we just have to be clear that that's the end of the road for the parent. They can't ever then sue because it was never found harmful to minors by the review committee and by one judge. But again, I'm concerned it's going to clog up our court system. Parents are going to be confused. Hopefully boards will make the process really clear. Parents are going to have their attorney ready within 28 days to file paperwork at a district court if they disagree with their review committee. It sounds like a very bureaucratic, difficult process to me. And I wish we would have cut sections out of the APA, the Administrative Procedures Act, and put them over here so it's clear that the courts could act. And I just want to make sure the body knew that that's the situation we're voting on. Thank you.